I think we all suffer from this fundamental misunderstanding about wealth, especially here in South Africa.
Hmm.
We put all our energy, all our focus into building it, the long hours, the saving, the smart business moves, but we completely miss the real danger.
The danger is exposure. We actually have a quote from one of our sources today that I think sums up our mission perfectly. It's,
Mm-hmm.
building wealth isn't enough. You have to protect it.
Right.
It's really an arms race against forces that can just liquidate a lifetime of work in a single financial moment.
Okay, let's unpack that because the deep dive we're taking today is it's critical for any individual, any family, or any business owner who has assets in South Africa.
Absolutely.
Our mission is to simplify the single most powerful tool for asset protection and legacy planning, the trust. And we want to show why it's not some, complicated thing for the ultra-rich, but an essential shield for you.
And this analysis, it isn't just theory. It's grounded in the often painful experience of wealth creators who learned this lesson the hard way. Our understanding is informed by expert trust consultants like Lumka Sturman, who specialize in helping South Africans get ahead of this before disaster strikes.
And to really get why this protection is so necessary, we have to look at the battlefield. I mean, our sources identify 7 major threats that can absolutely devastate an estate.
And we're fighting all of them at once. Trusts are designed to nullify these threats.
What are they?
Okay, so first you've got litigation and creditors, a sudden lawsuit. Second, divorce and matrimonial claims, which can just split a family's assets in half.
Mm-hmm.
Third is state duty, a heavy burden that can take up to 25% of your estate just because you died.
A quarter of everything.
A quarter.
Mm.
Then there's poor business succession planning, which often leads to a business collapsing after the owner passes. Fifth, you have the inevitable family disputes over who gets what. Always. And sixth, the forced sale of assets, selling a home or a business at a loss just to pay the tax bill.
And the 7th threat is maybe the most personal. It's the loss of control over how your wealth is used after you're gone because you didn't leave a clear, enforceable plan.
Right. That list covers professional failure, personal failure, and, of course, the certainty of death and taxes.
So let's jump straight into a case study that brings that first threat litigation into terrifying focus.
We need to meet David Nkosi. David is a 52-year-old orthopedic surgeon in Johannesburg, and he had, by all accounts, the ideal setup.
A profitable practice, properties?
Yep, valuable commercial properties, a great investment portfolio, a stable family. Everything was going right. He was, on paper, financially secure.
But then the system tested him.
It did. He was hit with a malpractice lawsuit for R$15 million.
Wow.
Now, David was cautious. He had malpractice insurance, but his policy, it only covered R$8 million.
So that leaves a 7 million rand hole, a shortfall he is personally on the hook for.
And here is the absolute crux of why this turned into a crisis. David, like so many of us, had structured his affairs, well, poorly.
How so?
Everything he owned was in his name. His practice, his properties, his investments, all of it was considered his personal property.
Which means it was all exposed. All of it was attachable for that R7 million.
Exactly.
Wait, but if those assets were his main source of income and he needed them for retirement, how could he possibly cover that without just destroying his future?
He couldn't. The fallout was catastrophic. To settle the claim and pay all the legal fees, the total financial impact was over R$12 million.
So it ballooned from 7 to 12.
It did. He had to sell a prime commercial property, and because he needed cash fast, he sold it at a loss.
Oh, that's brutal.
It gets worse. He had to liquidate a huge portion of his long-term retirement investments.
And liquidating retirement funds early. It's a double blow, right?
Yeah.
You lose the future growth, but you also probably get hit with immediate tax consequences.
Absolutely. When he sold those investment assets, it triggered a significant capital gains tax. So he lost the asset, he paid the lawsuit, and he paid tax on top of it. He even had to dip into the education funds he'd set aside for his children.
Oh, man.
The end result, he had to postpone his retirement by at least 5 years.
That one liability, that R7 million, it turned into a multi-million rand setback that just shattered his peace of mind. How could he have avoided all this?
With one single preventative step, taken just 5 years earlier, establishing a discretionary family trust.
And what would that have done?
If he had transferred his practice, his properties, and his investment portfolio into that trust, those assets would no longer have been legally his personal property.
Okay, walk us through that slowly, because this idea of separation is the missing key. If he's still running the practice and managing the buildings, how is the asset really separate?
That's an excellent question, and it gets to the heart of the legal concept.
Hmm.
So, while David and his wife, Dan Day, would likely be trustees managing the assets day to day, they'd be managing them on behalf of the beneficiaries, in this case, their children, not for themselves. The legal owner is the trust. It's a separate entity with its own bank account, its own tax number.
So the lawsuit against David personally?
It would have resulted in zero loss of family wealth. The R7 million liability just couldn't attach to the trust's assets. The separation, if it's structured correctly, is absolute.
The protection is immediate and absolute. So let's define this. What exactly is a trust in the South African legal landscape?
Okay, at its core, a trust is a legal arrangement. It's set up with a written deed where assets are transferred away from the founder or the donor to a group of trustees.
And the trustees manage it.
They do. They're legally required to manage those assets strictly for the benefit of the beneficiaries. The crucial takeaway here is the idea of a separate legal entity. Think of a trust like a vault that has its own identity, completely separate from you, the creator.
So David and Thandi were the trustees, giving them control to manage the practice, collect rent, live their financial lives, even though the trust owned everything. And their kids are the beneficiaries.
Precisely. They maintain management control, which is so important for business continuity. However, for a family trust to be legally valid, especially for asset protection, there's a requirement that has to be met.
Okay, that sounds critical. What is it?
You must appoint at least one independent trustee. This is someone who can't be the founder, a beneficiary, or closely related to them.
And why is that so important?
Their presence ensures impartiality. It validates that legal separation. If David had acted as the sole trustee, a court could argue the trust was just a sham to evade creditors, and then the assets could still be exposed. The independent trustee ensures that protective barrier is real and legally compliant.
That gives fantastic clarity on the structure. Are there different kinds of trusts?
We generally look at two main types. The living trust, or inter vivos trust, is created while you're alive. That's the powerful vehicle David needed for immediate asset protection.
And the other?
That's a testamentary trust, which is created in your will. It only comes into effect after you pass, usually to protect inheritances for, say, young children or vulnerable family members.
Okay, so we know how they work and how they stop disaster. Let's focus on the tangible, positive results. How did a trust help David rebuild, and what are the major savings listeners should be tracking?
Well, the first tangible benefit is that asset shielding we talked about.
Yeah.
It's a bulletproof vest. It protects assets from creditors and legal claims, essential for doctors, lawyers, entrepreneurs. And when it's structured properly, it shields assets from division during a divorce.
I have to challenge that point a little. Can a trust really make divorce protection absolute? Surely a court can pierce that veil if a marriage dissolves.
That is a crucial point of nuance. It's not an automatic shield. A properly structured trust, one that's established and funded before or very early in a marriage, with that independent trustee in place. It has a much, much greater chance of surviving scrutiny.
So it's about proving intent.
Exactly. It's about demonstrating that the trust was set up with a genuine fiduciary purpose, not just as a last-minute scheme to hide assets from a spouse. The timing and structure of the setup matter so much.
That makes perfect sense. Now let's talk about the generational wealth piece, that inevitable tax bill that hits every big estate in South Africa.
Estate duty. And this is where a trust delivers a massive, often multi-million rand advantage.
How so?
As we establish, the trust owns the assets, not David personally. So when David dies, those assets, they do not form part of his personal estate. They are not subject to estate duty. The projected tax on those trust assets is R0.
Zero. On assets worth millions, that's transformative for his family's future. What was the total saving in his case?
Looking at David's numbers, the total projected estate duty saved over 2 generations was about R6.8 million.
Wow.
And trusts don't die. They ensure perpetual ownership. They aren't subject to that winding up process, immediate tax bill that a personal estate is.
Now, we have to address the elephant in the room with tax. Trusts save on estate duty, but our sources warn that trusts themselves can be taxed quite highly if you aren't careful. A flat rate of 45% on retained income sounds terrifying.
It does, and that's a critical point to clarify, not to alarm you with. That 45% rate on retained income and the 36% effective rate on capital gains, they're intentionally high.
Why?
They exist to stop trusts from becoming pure tax shelters where people just hoard income forever.
So what's the strategy? How do you avoid that 45% trap?
The strategy is simple: distribution. Income generated by the trust, rental income, investment returns, whatever, is distributed to the beneficiaries, like the children, in the same tax year it's earned.
Well, what does that do?
Once distributed, that income is taxed at the beneficiary's personal marginal income tax rate, which is almost always significantly lower than 45%. This is why continuous professional guidance is non-negotiable. You have to actively manage that flow every year.
It's a tool, not a loophole. You have to actually operate it.
Precisely. And that leads to the final piece, succession planning. The trust facilitated continuity when David's son joined the practice. It provided a clear path for him to eventually take over the business and the properties. The business stays intact, generating income for the family without the risk of being sold off.
This all sounds absolutely essential, but setting it all up and maintaining it, dealing with the master's office, the tax code, fiduciary duties, appointing that trustee, it sounds incredibly complex. So easy to get wrong.
It is. This is not a weekend DIY project. Trusts involve detailed knowledge of South African law, tax strategies, and annual compliance. Trying to do this yourself is the fastest way to end up with a structure that fails when you need it most.
And this is where the role of a trust consultant comes in, someone to simplify that dense legal landscape. We mentioned Lemke Sturman earlier.
Exactly. Lemke's mission is really the antidote to this complexity. It's, and I'm quoting here, to educate and empower individuals, families, and business owners by providing expert trust consulting services that simplify estate planning and wealth protection.
So she shifts it from being a scary legal transaction to a clear strategic process.
That's it. In practical terms, it means she provides expert guidance that is tailored to your specific goals, whether it's protecting a property or planning for succession. She offers simplified solutions by translating the jargon into a clear roadmap.
So you know why you're doing what you're doing.
Exactly. And crucially, she ensures a holistic approach from the initial, meticulous setup right through to the ongoing management and compliance so the trust stays legally robust year after year.
That focus on education and simplification, that seems like the difference between a successful protective structure and a costly legal mistake. Who specifically should be looking at this kind of guidance right now?
I'd say anyone who is serious about their legacy. If you're a business owner planning for what comes next, if you're a family trying to secure your kids' futures, if you're an individual just looking to minimize that big estate duty bill.
Or even existing trustees who aren't sure of their duties.
Yes. If you're an existing trustee and you need help navigating your legal responsibilities, you need this guidance.
This has been an absolutely critical deep dive. We started by proving that keeping your wealth is the hardest part, and the trust is clearly that. That essential missing key to securing it and getting true peace of mind.
It is. It ensures your legacy endures, protected from those 7 threats. Before we finish, I want to leave you with a concrete action item, something you can do right after this.
Give us the homework.
Take 15 minutes and calculate your personal estate duty exposure. First, calculate your total net worth, everything you own, minus all your debts.
Okay.
Then subtract the R3.5 million primary abatement. That's the part of your estate that's automatically tax-free.
And that R3.5 million is the only thing standing between your wealth and the tax man. Everything above that is exposed.
Correct. Now, multiply whatever is left by 20%. That final number, that's the immediate tax bill due on your death. If that figure is substantially larger than the cost of setting up and maintaining a professional trust, then you have an undeniable financial reason to act now.
For those ready to move from exposed wealth to a protected legacy and to explore that kind of personalized professional guidance, the starting point is clear. You can learn more about starting your protection strategy and accessing expert guidance at www.lumenkasturman.com. It's about moving from being merely wealthy to being truly protected.